You are on bond for a theft, and now you've picked up another theft.
Right from the start, the judge is laying down the foundation. The defendant was already out on bond and still picked up 2 new charges. Courtroom tip: judges take bond violations personally. What do you think? Should picking up a new case automatically revoke bond? Or should people get another chance? Let me know in the comments.
And an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and put a speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale.
Hold on.
To purchase the item.
Oh, you didn't?
Yeah.
I was going to give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop. The officer was on scene when the complaining witness was attempting to stop.
Okay, pause. Running half a mile from Lowe's, that's not a getaway, that's cardio with consequences. Notice how the officer caught up on the 3rd floor of an apartment complex. This small detail matters. It establishes evading, resisting, and confirms probable cause. When law enforcement witnesses the chase directly, the judge's hands are pretty much tied.
The officer told the defendant to stop running, and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the 3rd floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129, and the defendant started to run from the complaining witness towards the nearby apartment.
Mr. Castillo, I'm going to find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, I'm now revoking your bond on your first case. You will now go into custody. I told you not to pick up any new cases. You've picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
Can you appoint him a lawyer, please? I will appoint you a lawyer now, and we'll talk, but no, you can't continue. Unacceptable. Are you Jackson Norton?
Sir.
Mr. Norton, you were charged with 2 counts of assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
February 15th, officers responded to 1025 West Mass Parkway, bar Buckwild in Harris County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. After the complainant turned around and the defendant struck him on the right side of his face. A second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it up, the second complainant grabbed the defendant, and the defendant turned around and punched him on the side of the head. The second complainant stated that he believed he was unconscious for multiple seconds. When he woke up, he was lying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed he still on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with a small laceration near the end of his eyebrow, where there was a small amount of blood. The first complainant advised he felt pain and had a small little bump on the end of his elbow next to his eyebrow next to his hairline.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No, Judge.
This is where things get serious. The judge brings out the ankle monitor restriction classic for repeat assault cases involving alcohol. Many people don't know this, but judges can tailor bond conditions based on patterns, like drinking-related violence. Quick question for you all. Should judges be allowed to set curfews this strict, or does it cross the line into micromanaging someone's life while they're still presumed innocent?
Same set of facts, whereas alcohol as well?
The previous assaults happened at a high school graduation party.
But there was alcohol?
Yes, Judge, it's not the fault of all.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
Yes, sir.
We're now working on our fourth, so I will do everything in my power to protect my public at all cost. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well.
Judge GPS. Whisper.
Sure.
9 to 6.
Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is the protection of my city, and I'm gonna do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take your seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application, sir.
Yes, sir.
Jackson Norton, you just gave him bond conditions, and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there. But his
So
job
what I said is he cannot go to any establishment where it's 50% or more, where there's like a true bar. If he's going to like a Longhorn Steakhouse, if he's going to, Papacitos, that's okay. But if you're going to a bar like the Marquee or you're going to, that's unacceptable. No bars, nightclubs, anything of this nature, because I don't want him to, we're working on our fourth assault now. No, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance, so he can be on call and may have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. My documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I'm not going to take his word for it that he gets up at 3 in the morning or 2 in the morning to go to this place and that place and, So, but show me something like that and then, yeah, we can work.
Okay, so we'll keep the curfew in place, and then if he needs to travel for work, we can provide proof that he's clocking in and clocking out.
Right. No contact with any of the complaining witnesses, no weapons, and then he's got the device on his ankle, so we know he's not consuming it too.
Is that a scram? Okay. So scram and GPS is what you're doing?
No, I didn't. Yeah, I guess so that we know that he's not out in the middle of the night, and if after some time, if he's good, then we can amend the conditions as far as the GPS.
Okay.
Scram.
30 to 60 days?
Be proactive, you know what I mean? Show me, I want to know that there are not going to be any more issues, but yeah, okay. Thank you.
7 to 7?
No. I don't know. He said he had a problem with 6. I didn't know. What did I do? I didn't do 7 to 7.
We're gonna do 9 to, the standard 9 to 6.
9 p.m. to 6 a.m.? I think he has to be at work at 6 a.m., right?
So, yesterday?
Can you
Okay, so I'll do 5 a.m.
5 a.m.? 9 p.m. to 5 a.m.? Okay.
So just yesterday, I worked from 6 to 11 at night.
Yeah, I'll give 5 in the morning.
Thank you.
Yeah. But don't want any more issues.
Natalie Curley, can I do midnight? Because sometimes it's 30 minutes to drive back home and I get off at 11.
Not giving you till midnight. It's not going to happen. And I want proof of anything that, as far as work is,
Work-wise, like
I'm not going to take
or
your word for
something?
it. So I need proof that, that they're actually working at this time and then we can work on your schedule, but I'm not letting you out in the middle of the night. It's not going to happen.
Sir.
Okay? Thanks.
Judge, 9 to 5, Judge. 9 p.m.
9 to 5, right. Yeah.
So we're gonna amend this.
So, Mr. Ibarra, you were charged with driving while intoxicated, second offense.
Yes, sir.
You have worked out an agreement. They're offering you 30 days in jail, credit for the 2 days that you've done. You need to understand something very important, that you are making a lifetime decision today, and a very serious one, because anytime you get pulled over from now on, an officer is going to look you up and they're going to see DWI, yada. What do you think they're going to do if they come up to you and they smell alcohol?
Don't say to jail. Bring us to jail again.
Right. This time, though, you're looking at 2 to 10 in the penitentiary.
Sure.
Because then a third DWI, it's a third-degree felony. You're looking at a whole boatload of time in custody. Up to 10 years in prison. And all you need to do is just have the faintest smell. Do you understand?
Yes, sir.
If I were you, even if you had a sip of alcohol, I wouldn't get into a car because it's a huge risk. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this, it will go on your record. It'll stay there for the rest of your life.
Understood.
This is what you want to do.
Yes, sir.
How do you plead to the offense, sir?
Guilty.
I will find you guilty, sentence you to 30 days in jail. I will give you credit for the 2 days that you've done. I am going to suspend your license for 1 year. What do you do for a living, sir?
I work at a refinery. HVAC thing.
Okay. The reason I'm asking you is because there is a surcharge that you're going to be required to pay. We will give you time to pay it, but this is a second offense, so you're going to be required to pay it. It's a $6,000 surcharge that tacks onto you, and if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand?
Yes, sir.
I'll waive the court costs.
Yes,
He's
Your
going to
Honor.
be required to pay that fee.
Yes, Your Honor. And Your Honor, I did have one request that I wanted to put forth before the court. Due to his job, he is a foreman at his job. I wanted to see if possible if the court would consider allowing him to do his jail time on weekends.
No, like
He
you
said
said,
he can literally do every weekend until it's satisfied.
we're not allowed to do that.
I explained to him the court's general rule.
All right, you're going to have to do it flat. It'll be easier now. If you want to go in later today, by 6 p.m., we can do that. If you want to go in now, you can go do that now, but it's got to be a continuous
Yes, sir.
stretch. What do you want to do? You want to go in now or do you want to go in later
Bring it
today?
down.
Right now?
6
Yes, sir.
p.m.
Okay. All right. So Deputy Miranda, do you mind remanding him into custody so he can serve his time?
Be back in a minute. All right. Thank you, Your Honor. I'll be excused. Have a good weekend. I told him the court's policy, Your Honor, but he
Yeah.
still wanted me to ask.
The problem is that it costs way too much in man time.
Yes,
We don't
sir.
even do sweep anymore, which is like a work release program. They don't do any of that anymore since COVID. It's
Okay.
all,
All right. Thank you, Your Honor. Have a great weekend.
let me see. Okay, guys, yeah.